name is Yolanda Fair, and I'm the project attorney for OJD. And we are grateful that you are joining us for our virtual training series. Today, we have Terry Johnson, who is an assistant juvenile defender for the Western region of our state, who's going to be talking about some of the common issues we face when we have kids who will possibly be placed on the sex offender registry. She's going to give an overview of what to look for and some of the common situations we may find there. But again, Terry is the assistant juvenile defender for the Western region of our state. She graduated from Duke University in 2000 with a Bachelor's of Science in Psychology, and then received her JD from the University of North Carolina Chapel Hill School of Law in 2023. She has been practicing juvenile delinquency and criminal defense family law since 2003, became a certified specialist in juvenile delinquency law, and is an avid, fierce defender in the courtroom when it comes to youth. It is my pleasure to turn it over to her, and she will get us started. If you have any questions as we go along, please place them into the chat. I'll monitor it for Terry, and we'll take questions as they come in.
Okay, so hopefully everyone can hear me. If you can't, please put that in the chat as well. As Yolanda said, this is going to be kind of a broad overview of the laws of juvenile registration for North Carolina, and then we're going to talk a little bit about the interplay with the Sex Offender Registration Notification Act and how that comes into play. So this presentation is going to be a little heavy on collateral consequences and the statutes and how to appropriately advise your clients when you have a youth who is charged with a sex offense in the state. That said, one of the things that I have noticed in practicing over the years is that a lot of attorneys, judges, court counselors, law enforcement have a little bit of a misconception about juvenile court in general with regard to sex offenses, thinking it's not going to follow a client. So I was looking for stories that might be sort of the cautionary tale to start the presentation, and in talking to some other attorneys, I personally don't watch a whole lot of professional sports, but I had an attorney mention to me, oh, you might want to talk about this particular case with this baseball player. And so to that end, we have an individual named Luke Heimlich, who was a very talented college baseball player and was such a good pitcher that he was being actively looked at, recruited by lots of Major League Baseball teams. They constantly came and watched his games. His team was set to play in the College World Series. And right before they were set to play in the College World Series, a reporter broke the story that he had been charged and adjudicated of a sex offense in Washington State. What had happened in this particular case was that Luke was like a lot of our clients. He was accused by a relative of a particular type of sex offense. He had a lot of discussions with his attorney, with his family, had been told this won't follow you if you handle it in juvenile court. Got a lot of misinformation about how sex offenses impact a youth going forward. And ultimately, he and his family decided that he would do an admission based on all of that information. Now, he gave interviews much later saying if he had known fully the impact that this was going to have on his life, he would not have taken an admission. He would have actually gone to trial in this case. As it was, he did the admission, he successfully completed probation, he applied to school, and ends up enrolling at Oregon State. At some point before he is supposed to play in the College World Series, he had gotten a traffic ticket and missed his court date. When he missed that court date, it flagged in the system. DAs and other professionals started looking into it. I think he ultimately had either a failure to appear or an actual order for arrest. I don't remember the exact details of that story. But because of that, his juvenile record came up, and he was actually charged with failure to register as a sex offender in Oregon State. Once he was charged, of course, the story broke national news. There were a lot of news articles on it, a lot of coverage, and it destroyed his Major League Baseball opportunities. He would have been a top recruit that year. As it was, he took himself out of the runnings in the College World Series. He did not play his last baseball game. All of the teams that had been recruiting him decided not to draft him. He ultimately ended up playing for a team in Mexico. That career was short-lived as well because lots of other teams found out about this, obviously, because it was public information. His failure to register charges were dismissed ultimately because he didn't know he was supposed to register. He'd been given all of this misinformation thinking that his case was done. He was off of juvenile probation. He had had no more offenses. But this is obviously the cautionary tale because this is a person who had an incident in his youth that followed him and affected him very long term. And if he had not been given incorrect information, he likely would have made different decisions about how this case was handled in the court system. So going forward, that brings us to the sex offender registration statutes for juvenile court. So hopefully most of you do juvenile cases. I can't again see the chat, but if you may want to take the opportunity to put in the chat whether or not you do juvenile cases, juvenile and adult cases, and what your experience level is with sex offenses in general, because most of this, as I said, is going to cover juvenile cases, but there's going to be some overlap with the adult statutes. 7B2509 is the juvenile registration statute, and it states that in any case in which a juvenile is at least 11 years of age at the time of the offense, if they are adjudicated delinquent for attempted rape or sexual offense, first-degree forcible rape, second-degree forcible rape, first-degree statutory rape, second-degree forcible offenses, or first-degree statutory sexual offenses, then the judge, upon a finding that the juvenile is a danger to the community, may order that the juvenile register in accordance with Part 4 of Article 27 of Chapter 14. So that is the juvenile registration code. You may notice from this, it is largely the high-level felonies, the B1 felonies, that are the offenses for which a juvenile would be ordered or could be ordered to register. However, you have to also read with that Chapter 14. And under Chapter 14, it sort of duplicates the language of 7B2509. It adds a little additional language that makes it more mandatory than discretionary. And to that end, it says that the court shall consider whether the juvenile is a danger to the community. And if the court finds that the juvenile is a danger to the community, then the court shall consider whether the juvenile should be required to register with the county sheriff. So again, a lot of mandatory language there. And if you're paying particular attention to that, the court shall consider. There's no discretion for the court to not consider. The reality is that what happens in juvenile court is you get to disposition and there's no request made for registration because at this point you've had disposition reports that have been handed up. You've normally had a comprehensive evaluation of sexual harm completed, and so there's recommendations that are already built in there. So we don't see this a lot, but you need to be aware that it is built into the statute that the court has to consider this. And in fact, Part B of this statute states that the determination of whether the juvenile is a danger to the community and whether the juvenile shall be required to register shall be made by the presiding judge at the dispositional hearing. So even if your county does not normally request registration, you need to be aware that the statute exists, and you need to be prepared to make arguments at disposition for why your client should not be ordered to register if you have a youth who is charged with these offenses and is adjudicated ultimately of those same offenses. You need to also be aware, for purposes of negotiations, a lot of times we look at 7B2509 and you would think based on that it's only those offenses. So if you plead your client's case down to attempt or solicitation or aiding and abetting, that might somehow help your client. But Part C states that subsection A1 includes the commission of the enumerated offenses as well as attempt, conspiracy, solicitation of, or aiding and abetting any of those offenses. So be aware that if you negotiate some sort of agreement with your client thinking you can avoid registration by doing this, the statute actually says that they can be forced to register based on those types of offenses as well. So again, sex offender registration statutes 14-208.7 goes into some of the requirements of the registry itself. And important for attorneys here and across the nation, a person moving to North Carolina from out of state must register within 3 days of establishing a residence or within 15 days, whichever comes first. So if you have a client who is living on the border, Virginia, South Carolina, Tennessee, Georgia, if they have crossed over state lines, stayed with a family member, had an offense, and then they're going to move here permanently, you need to be aware of this statute because it does direct what happens if they are coming from another state. And sometimes we do get phone calls from out-of-state attorneys even asking what happens if this kid is on probation and they move to North Carolina. North Carolina generally will follow whatever the home state puts in the order. So if the home state says they have to register, then they would have to register here. So a non-resident worker or student with a reportable conviction or who is required to register in the person's state of residency is required to register where they work or attend school. So again, if you have somebody who is not establishing residency but they attend school here, that could also be an issue. Now, as far as the information that is included in the registry, if you have a client who is ordered to register, even though it's a juvenile registry, the information that is required to be included is very extensive. So it includes the person's full name, any alias that they go by, so nicknames, their date of birth, sex, race, height, weight, eye color, hair color, driver's license number if they have one, and their home address is required to be included. They have to have the type of offense for which they were convicted, the date of conviction, and the sentence imposed. Now, the language in the statute says convicted, but it is the statute for the information that's required in even the juvenile registry. So if they were adjudicated, that would be the information that's included. A current photograph taken by the sheriff at the time of registration. So your client could potentially have to be photographed. The person's fingerprints must be taken at the time of registration. Usually, as you know from the offenses that are registrable for juveniles under 7B2509, those offenses are all felonies. So most of the time, these clients will have already been fingerprinted. They may have to be fingerprinted again when they go to register if they're ordered to do so. The name and address. Yes.
There was a question in the chat. It says, if the judge fails to address the registry at disposition, will it default to requiring registration or will it default to no registration?
No registration. So in order for a juvenile to be placed on a registry, they have to have a court order saying so, because the court has to make specific findings of fact about the danger to the community. Any other questions?
No, not yet. But I'll keep watching it.
Okay, so additional information that needs to be included: the name and address of any educational institution the person attends or expects to attend. So if you have a client who is applying to colleges, this could be a potential issue for them, that they would have to provide that information to the registry. The name and address of employment at any institution of higher learning. So if somebody wants to go and work in a cafeteria, or if they want to work as a custodian or an assistant to a teacher, that might be something that they have to provide as well. And then any online identifier that the person has or intends to use. So email addresses, social media accounts, all of that information has to be provided for purposes of the registry. So if you have a client who has been ordered to register and they change addresses, just like with an adult, there is a process for this. If a juvenile court counselor finds out that a client is going to move, and you know from practice that most orders contain language that says that the parent and the juvenile shall notify the juvenile court counselor of any changes in their address. If the juvenile court counselor has that notice, then they have to provide written notice no later than the 3rd business day after that change to the sheriff of the initial county of registration. So you notice that it's the juvenile and parent notify the court counselor notifies the sheriff. Your client wouldn't have to notify the sheriff themselves. The sheriff then has to immediately notify Department of Public Safety. And if that move is to another county within North Carolina, Department of Public Safety has to make notification to the sheriff of the county of the juvenile's new address. Registration is semi-annual for juveniles. So every year on the anniversary of the initial registration and every 6 months after that, the sheriff shall mail a verification form to the juvenile court counselor. And again, the obligation is on the sheriff. They mail the form to the juvenile court counselor, and then the juvenile court counselor and the juvenile have to meet, sign the form, indicate any change of address, and return it within 3 business days of receipt. Registration is not public. I will caution you here just a little bit. We still have to get to SORNA, and we'll address that a little bit later in the presentation. But generally speaking, for juveniles, registration is not public. Again, however, information is not public, but it is released to law enforcement agencies and local boards of education. The piece about local boards of education is important because you need to be aware that some schools are taking this information and they're using it to decide whether or not a student can remain enrolled in regular school, alternative school, or if they need to have homebound or virtual services. Registry information for any juvenile enrolled in a local school shall be forwarded to the Board of Education. Board of Education should not be making this information public. That still goes to confidentiality rules, but they do notify the individual school. And as you know, if a juvenile is adjudicated of a felony, the school gets notification of that. Now, we'll talk a little bit about House Bill 834 somewhat throughout this presentation, but one thing that you need to be aware of for that is that the confidentiality sections of the statute were modified just a little bit, in that it was any felony adjudication and any felony charge, the school would get notification of it. Now it is A through E felonies. Obviously, that covers these offenses, the registrable offenses here, that the school would get notification. But the notification is supposed to go to the principal. So the juvenile court counselor is supposed to notify the principal of the school that the juvenile attends. And then the statute was further modified to say that the principal has to make an individualized decision about the student and whether or not they can attend the school, and they are not allowed to have automatic suspension policies. There was nothing modified to say what your remedy is if they are doing automatic suspension in that statute, but you need to be aware that it exists because you may be able to use that information to assist your clients if they are being long-term suspended from school because of these charges or adjudications. So termination of registration in juvenile cases is a little different than it is in the adult system. The requirement is for them to register obviously register, and then once they are registered, it terminates automatically on their 18th birthday or when jurisdiction of the juvenile court ends, whichever occurs first. So if you have a client who has completed probation successfully and the court's terminated their jurisdiction, juvenile court counselor has approached a judge and gotten a termination order, their requirement to register at that point should terminate. If it has not, for whatever reason, then it automatically terminates whenever they turn 18. The Criminal Information Network is also part of this process, and there is a statute 14-208.31 that I would encourage you to look at, because under that statute, it says DPS shall maintain registration information permanently, even after registration and reporting requirements expire. Those records are still supposed to remain confidential, but they stay there basically forever. So be aware of that. All of these offenses, the registrable juvenile offenses, again, they're the A through E felonies. They fall in that category, so they're not eligible to be expunged. So even if you thought, oh, maybe I can just expunge these and that might take care of the Criminal Information Network, it won't, because they're not eligible for expunction if it's any of those violent classified offenses. You should know this, but just in case, just a note to this point, if a juvenile is transferred to Superior Court and tried and convicted as an adult, they are subject to the adult registry requirements. So that includes registration on a public registry. And one thing that I wanted to make very clear on this point is if you have a youth who is transferred to Superior Court and they have an offense that is not a registrable offense in the juvenile system, but it goes along because it's related to the other offenses, so it's sent up to Superior Court with everything else. So, for example, a sexual battery that tracks along with it. In juvenile court, sexual battery is not registrable, but in the adult system, it obviously is. So if that client gets transferred to Superior Court and they are ultimately convicted, they are still subject to registration regardless of the date of offense, because they are convicted as an adult. So House Bill 834, I mentioned we were going to talk about this at least a little bit. The definition of juvenile is changing yet again. And to that end, it now says offenses excluded from the definition of delinquent juvenile when committed while 16 or 17 include the following. Same as it always was, all violations of Chapter 20 offenses are still excluded from the definition of juvenile. But also now, if a juvenile is 16 or 17, any offense that is punishable as a Class A through E felony, if committed by an adult, together with any offense based on the same act or transaction, or a series of acts or transactions connected together or constituting parts of a single scheme or plan of that offense, and any greater or lesser included offenses, those will now be charged in the adult system effective December 1st of this year. So you could have a youth who is 16 or 17 and is under investigation for a sex offense that happened prior to December 1st that will be charged in juvenile court and subject to the possibility of indictment or PC and then transfer. Or you could have a 16 or a 17-year-old who was charged after December 1st for an offense that happened after December 1st, and they will be charged as an adult. So you need to be aware of the statute so that you know when you have these offenses for any minor who is 16 or 17, look very closely at their date of offense and their age at the time of the offense so that you can be sure that they were charged in the correct trial division. Again, transferred youth, if they are tried and convicted as an adult, subject to the adult registry requirements, those are covered under 14-208.6b all the way to 208.32. Any youth transferred and convicted of a sexually violent offense or an offense against a minor has to register in person, just like an adult convicted of the same offense. So they have to show up, they have to register. They would have all of the same requirements as far as maintaining that registry. Like, I know that a lot of places will require, on Halloween, for example, registered sex offenders to show up in person and report at the local sheriff's office. So if they are an adult or charged and convicted as an adult, they have to follow all of those same rules. Again, those rules are generally found in Chapter 14. Sex Offender and Public Protection Registration Program applies to any person convicted of an offense against a minor or a sexually violent offense. And thinking that through for us as juvenile defenders, most of the alleged victims in these cases are going to be minors because they tend to be younger family members or the younger sibling of a friend or a family member. Just by virtue of the fact that we are dealing with minors ourselves, the alleged victims are typically going to be minors. And then there's the Sexually Violent Predator Program, and it applies to any person who is considered a recidivist, who commits an aggravated offense, or who is determined to be a sexually violent predator. We will talk in a little bit about what is an aggravated offense. So over the past few years, there's been some litigation concerning the constitutionality of satellite-based monitoring for sex offenders, which is where this aggravated offense information comes in. So some of these cases, there were a series of cases. State v. Grady was litigated in particular. It had several different rulings in it, where many of the issues that were litigated brought forth some legislative changes that happened in 2021. So if you have a youth that could be subject to satellite-based monitoring because they've been transferred up, just a little bit of a rundown of the statute is here. And again, general requirements are conviction of a reportable offense under 14-208.64. I won't read through all of that. You can look through that yourself, but it requires a court finding that either the person is a reoffender, a sexually violent predator, convicted of an aggravated offense, and for purposes of aggravated offense, that is any sexual act involving vaginal, anal, or oral penetration with a child under 12. And again, with the ages of our clients, sometimes the alleged victims are going to be similar in age there. Convicted of a violation of 14-27.23 or 14-27.28. Those are the statutory sex offenses where the offender is 18 or older, so we don't generally have to worry about that for juvenile purposes, but for adult purposes you might. And then conviction or convicted of the physical, mental, or sexual abuse of a minor. And again, that one might come into play for us. Again, they are required to have a risk assessment completed by Department of Public Safety. So that is part of the recent legislative changes that came out of State v. Grady. Prior to that litigation, all recidivists were required to have satellite-based monitoring. Now they all have to have a risk assessment for every person who is convicted, and then that risk assessment would determine their level of monitoring. So if you have a client who has been transferred up and they are subject to satellite-based monitoring, the length of time, there is a 10-year cap for individuals that were previously required to have satellite-based monitoring for life. Period is not to exceed 10 years if the offense involved the physical, sexual abuse of a minor, but was not an aggravated offense. So those cases that we talked about a little bit previously for satellite-based monitoring, the ones you may want to look at, Grady versus North Carolina, that's a U.S. Supreme Court case, held that satellite-based monitoring is a search. State v. Grady in North Carolina, when it was still in the Court of Appeals, held that satellite-based monitoring is unconstitutional for unsupervised recidivists and unreasonable search for those who are no longer supervised. And then from 2020, we have State v. Thompson, which held that a 10-year period was not overly burdensome for a defendant convicted of multiple sexual offenses against children and who was going to be on parole for at least 5 years. Questions about any of that so far?
No questions in the chat, but I did note that we will send a copy of the PowerPoint with our follow-up email.
Okay. So the biggest legislative changes that came, again, out of those cases, reoffender versus recidivist, those definitions, and then the risk assessment that's now required for all individuals under consideration for satellite-based monitoring, and the 10-year time period cap. For purposes of this, Yolanda, I don't know if you can look at my PowerPoint and put this into the chat for people, but there's a School of Government blog by Jamie Markham, and it is revisions to North Carolina satellite-based monitoring law. It has a lot of the revisions and a lot of good information about what has changed and how to navigate that particular issue for your clients. So I would encourage you to read through that as well. It is included as a resource at the end of this PowerPoint. So if we email that out, people will have it anyway, but just in case anybody wants to go ahead and sort of skim through it. So before we get to SORNA, just some tips generally for any defender who has a juvenile or a minor who is charged with any type of sex offense. You need to read 7B 2509 in conjunction with Chapter 14, because obviously there's a little bit of different language between the two, so you need to know exactly what might be coming for your client. Be prepared to argue danger to the community at disposition. And note that there is no notice explicitly required in the statute for this. So you could come to court and have a disposition report where the court counselor is not recommending registration, but have a DA say, oh, I'm asking for registration, and you need to be prepared to do that hearing. Make sure that you've got as much information about your client before you get to disposition as possible. Adult punishments and registration should be discussed with any of your clients, 16 and 17, and any client who could be transferred. So anybody 13 to 15, and anybody 16 and 17, make sure you were discussing collateral consequences with them in general, but especially if they are charged with a sex offense. And note that this includes items that are not enumerated as registrable offenses in 7B 2509, because again, and we'll get into this in more detail once we go into SORNA, there are offenses that are not required to be registered as a juvenile offense, but if they're 16 or 17 and it tracks upward with another offense, they could have to register for those as well. Request that your records in these types of cases be sealed. So for most cases like this, if you have done this work, then you know we used to call it sex offender specific evaluations, so the SOSA evaluations. Some counties now call them CESH evaluations or comprehensive evaluation of sexual harm. Those evaluations are very in-depth. They go through a lot of personal information. There will be information and questions asked of your client about their past history, what happened with this specific offense, have they ever been the victim of a sex offense themselves, mental health diagnoses that exist, any school issues. They are so in-depth and cover so much information that it is damaging to your client to leave that information in a fashion where people can see it. So obviously we look at juvenile records and say, well, they're confidential and there's a limited number of people who can access those records without a court order. With a court order, people can see those records. So if somebody does get a court order to release those records, then obviously that's a big deal. And again, even without it, the parents of the kids can see it, the juvenile can see it, the DA can see it. Probation officers are allowed to access certain things for purposes of establishing their level of supervision even as an adult. So you should be asking at a minimum for these cash evaluations to be sealed in the file so that they cannot be opened by anyone without a court order. You can ask for the entire file to be sealed, but again, at least ask for these evaluations to be sealed. Note that the juvenile adjudications can be used as 404B evidence in subsequent prosecutions as an adult. So language is admissible evidence may include evidence of offenses committed by a juvenile if it would have been a class A through E felony. So make sure that you're aware of that and that you at least mention it to your client so that they know that this is something that could still come back and harm them later on. So with that, that brings us up to the Sex Offender Registration and Notification Act. And I'll go into a little bit of the history of this. You'll recognize probably from these pictures Adam Walsh and John Walsh, who were the impetus for the passage of the SORNA Act. Just a little bit of history and background. SORNA is the Sex Offender Registration and Notification Act. It is also known as the Adam Walsh Act and was passed in July 2006. It replaced the Jacob Wetterling Act, which had set up baselines for sex offender registration in the first place. And then Megan's Law was part of the Wetterling Act, and it is what made the sex offender registry, or at least parts of it, public. Every state has enacted some type of registration procedure that complied with the Wetterling Act and Megan's Law. Now that said, just again for a little bit more history on this, Jacob Wetterling was an 11-year-old who was kidnapped and murdered in 1989 in Minnesota. His remains were not found until 2016, and the perpetrator eventually pled to federal child pornography charges in exchange for not being prosecuted for Jacob's murder, and leading investigators to his body. And he had to also testify in a hearing about what exactly happened so that the family had some closure. Jacob's family established the Wetterling Foundation, I believe was the name of it. And they went forward with pushing for and lobbying for legislation that ultimately led to the sex offender registry being created in multiple states. Again, in that case, it was a pretty egregious case, the kind that covered a lot of national attention, got a lot of attention because the facts were so heinous. There were 3 boys, including Jacob, his brother, and a friend who had gone to a store in the summertime, and they were just hanging out. And the guy who kidnapped Jacob ultimately wore a mask, confronted all 3 boys at gunpoint, told Jacob's brother and the other boy to run into the woods and don't look back, and he wouldn't take them. He took Jacob instead. And of course, the family, once they discovered all of this, became very active in lobbying and legislation that went on for some years. And then it was modified by Megan Kenka's family. Megan was a 7-year-old who was raped and murdered by a neighbor in New Jersey in 1994. They ultimately found out that the neighbor had 2 prior convictions, and Megan's family likewise lobbied for changes to make the sex offender registry public so that people would know where are sex offenders living. Are they close by? Are they living in their neighborhood? So ultimately, SORNA, or the Jacob or Adam Walsh Act, replaced the Wetterling Act and Megan's Law. And in Adam's case, he was abducted and murdered from a mall in Florida at the age of 7. No one was ever tried or convicted for his particular case, but obviously you've probably seen John Walsh on America's Most Wanted and other shows like that, and he's been very active in lobbying for changes that ultimately led to the Adam Walsh Act being passed, and it organized sex offenses into 3 tiers, with the 3rd tier being the most serious. It also created the national database for searchable information about people registered as sex offenders. 2 primary objectives of SORNA were creation of that new federal offense for failure to register as a sex offender, and then establishment of the new baseline sex offender registry standards for jurisdictions. And again, it did establish those 3 tiers of offenses that set out what would be considered the most serious offenses and the length of time for registration for those offenses. So compliance with SORNA, this is a map pulled off of a Department of Justice website that tells which states are in compliance. So the states that are in green, and you can see North Carolina surrounded by states in green, are the states that comply with SORNA. Okay. So there are 18 states currently that are in full compliance with SORNA. Again, you saw that most of the states that are surrounding North Carolina, with the exception of Georgia, are in compliance. We have U.S. territories also that are in compliance. So American Samoa, Guam, the Commonwealth of the Northern Mariana Islands, and the U.S. Virgin Islands are in compliance. And then importantly for North Carolina, tribal jurisdictions. So there are 135 tribal jurisdictions that comply with SORNA, and that includes the Cherokee Nation and Eastern Band of Cherokee Indians. Under SORNA, there are specific registration requirements, and they are similar to, and in all of the wording, to North Carolina's registration requirements. So if you pull this statute under the federal code and look at all of the language, you'll note that it is very closely linked to North Carolina's. Even the tiers and the description of the tiers is very similar. So under SORNA, persons convicted of sex offenses and non-parental kidnapping of a minor must register. And so this includes sex offenses other than those enumerated in 7B 2509. Any sex offense with a victim under age 12 would require registration under federal law. SORNA also requires that juveniles who are at least 14 years of age at the time of an offense, who are adjudicated delinquent for a crime comparable to or more severe than an aggravated sexual abuse crime as defined by federal law, must register as sex offenders. Aggravated sexual abuse has a very lengthy definition with multiple parts to it. So for us, what qualifies is that any person who knowingly engages in a sexual act by using force against that person, or by threatening or placing that person in fear of being subjected to death, serious bodily injury, or kidnapping, or attempts to do so, that qualifies as an aggravated sexual abuse crime, and the punishment under SORNA would be imprisonment for any term of years, life, or a fine, or both. It also states aggravated sexual abuse includes any person who knowingly renders another person unconscious and engages in a sexual act with that person, or any person who gives another person by force or threat of force, or without their knowledge, a drug, intoxicant, or other substance that is intended to and does substantially impair the person's ability to function or have control of their body, and then engages in a sexual act with that person or attempts to do so, is guilty of an aggravated sexual abuse crime and shall be, again, under this, fined, imprisoned for any term of years, or life, or both. And then Part C, aggravated sexual abuse is also defined as any person who knowingly engages in a sexual act with another person who has not attained the age of 12 years old or attempts to do so shall be fined under this section, imprisoned for a term of life, years, or also have both a fine and that imprisonment. This one I highlighted because, again, for us, a lot of the time, our clients are charged with sex acts with persons who are 12 or under. The state of mind requirement, just like with North Carolina for statutory sex offenses, not knowing the person's age is not a defense. So your client saying, I didn't know that they were under 12, it doesn't matter. They're expected to know the age of the person that they're with. The registration requirements, again, under SORNA, any finding of guilty triggers registration. However, under SORNA, adjudications count as a finding of guilty. Some states and jurisdictions have only partially adopted SORNA. Part of that is because this was tied to federal money. Some of the states that adopted it were given money for law enforcement purposes, and there were some states that looked at this and just felt like the requirements were too stringent and were in contrast and in direct contradiction to what they felt was appropriate for juveniles. So we have states that have partially adopted, completely adopted, and some states that just said we're not adopting at all. And you need to check if you have a client who's going to move to any of these different states, contact that state, contact an attorney in that state, ask them registration requirements so that you can help your client and advise them appropriately. Some jurisdictions require registration when a person has been civilly committed. If they've received what's called a withheld adjudication, that I couldn't find that defined anywhere in the statute, but it did say withheld adjudication, or if they have been found not guilty by reason of insanity or incompetent to stand trial, they could still be placed on a registry, or when ordered to register by a probation officer. And I am assuming that that means that in some states, they are allowed to have a probation officer tell them that they have to register without a court order. Not 100% sure about that, but that's the exact language that was listed in the SORNA statute. So again, some of the requirements, SORNA does not require jurisdictions to disclose information about juveniles on public registries. However, it does allow states to implement more restrictive requirements regarding traveling or moving, or in just registration in general. And so what has come up is some states have said they didn't want to be considered a safe haven for people who would otherwise be registered sex offenders. And so some states have enacted very strict laws about if you were adjudicated as a juvenile and you move to this state, you'll be required to register. So you need to be aware of that. Registration requirements following move across state lines do vary by state, especially in terms of what qualifies as a move. Move can include attending school, placement in a group home or treatment facility, or even just overnight stays. So if somebody went on vacation for a week or 2 weeks in a particular state, that could ultimately be an issue. Some practice tips to be aware of for those juveniles who are charged with sex offenses. SORNA divides the sex offenses into 3 tiers to determine the registry requirements. Again, Tier 3 is the most serious one, but Tier 2 includes production of or distribution of child pornography and abusive sexual contact committed against a minor 13 years or older. Again, we obviously have clients who get charged with distribution of child pornography because they've taken pictures of themselves or their girlfriend or their boyfriend and they showed it to somebody else. So be aware that issue exists as well, because that's not one of the enumerated registrable offenses for juveniles, but it is an offense that for purposes of SORNA, if they move, especially if they move while they are already on probation, this could become an issue. A lot of states will say, and North Carolina is one of those, that if you are on probation for a sex offense and you move to this state, they're going to go through the ICJ and look at what's the order say. And if the order says register on a juvenile registry, then that's what would happen. You register on a juvenile registry. If it doesn't say that you have to register, then you don't have to register. But that varies depending on the state. So just be aware of that specific information. And then in addition to that, you move while you're still on probation and you move to a state that follows SORNA, your client might end up on a public registry. Tier 3 includes offenses committed against a minor under 13 years of age and kidnapping. So again, just the ages of our clients, this is an issue. We've had some clients recently that have been charged with kidnapping for something as simple as standing in front of a door and saying, "Oh, you can't leave yet." So be aware of that as well whenever you have kids who are charged with something like that. That's something that you need to be negotiating hard to get your DAs to see if they will get rid of that piece. Even pleading it down to second-degree kidnapping would not help. Under 7B 2509, again, the enumerated offenses are Tier 3 offenses for which lifetime registration would be required under SORNA. So you need to be aware of that because those offenses in particular carry the more serious consequences. The duty to register following a move to another state can still exist under SORNA, even if that state's laws regarding registration or North Carolina's laws did not require it. Even if your client has completed probation successfully and jurisdiction is terminated, so their registration requirement has terminated by the state of North Carolina, we don't require it at all anymore. If they move to another state that follows SORNA, they could still be ordered to register there. So they have to be aware of this and know this information before moving. Usually it comes up when somebody moves and they get another criminal charge or they get a traffic ticket. They fail to appear, just like in the case at the very beginning of the presentation. So normally this doesn't become an issue unless the client has something else come up. But if you have a client who moves and they tell their girlfriend or boyfriend or whoever that they had this offense as a juvenile and they registered, but they no longer have to register, and that person gets mad and reports them for something, then you might end up in a situation where your client could potentially even be charged in a federal court with failure to register as a sex offender. And obviously that's an active sentence. Registration following a move to another state may be subject to registration again on a public registry, even if it was resolved in juvenile court. Cannot stress that enough. The fact that it was a juvenile case doesn't mean that they could not be forced to register publicly following a move, depending on the specific state. I'll get into some of the resources at the very end of this, but there is a website that you can go to that again shows you that map with the states that are completely SORNA compliant, but it also gives you contact information for an office that you can call and ask questions to find out if this person had this type of offense and they're no longer forced to register. You can ask, would they have to register there? Typically, I would say it would be better for you to call an attorney who is licensed in that state to ask those questions. But if you can't find someone, there is a website that you can go to try to look at the registration requirements. And again, juvenile adjudications can be used to enhance federal sentencing. We don't think about this maybe quite as much, but I have had at least one client where he got federal charges after he had reached the age of 18. I think he was in his early 20s and was charged in federal court. And the federal court was looking at his juvenile record for enhancement purposes, and I was asked to write a letter on his behalf to try to assist in that case. And ultimately, the letter did help, but because these charges are high-level felonies, you do need to be aware that that is something that does exist. I would encourage you to hold on to those files a little bit longer than what the state bar requires, because it is difficult to recreate information and to get that information once you've shredded a file or put it in long-term storage. So just be aware that you could have that come up.
Here, there is a question in the chat. It says, is a youth required to register in a SORNA compliant state, even if not required to register in North Carolina, and is no longer under North Carolina juvenile jurisdiction?
Yes. Yes, that's the impact of the way the statute is worded, is that if you're moving to another state, if you have been adjudicated of one of those sex offenses and you were 14 or older at the time of the offense, then yes, you could be required to register. And again, it typically is going to come up whenever there's a move and somebody gets another criminal charge or a traffic ticket, or they somehow get reported. But from a legal standpoint, yes, they are supposed to register if they're in one of those SORNA compliant states, and they can be criminally charged in a federal way or in state court, or potentially both if they don't register and they're in one of those SORNA compliant states. And again, that was sort of the next point. So failure to register can be a separate federal crime, punishable with, again, the fine, imprisonment for up to 10 years, or both. if they don't register. So even if the state doesn't, if that specific state doesn't prosecute them, the federal courts in that system could. The tiers are a little more expansive under SORNA than they are under the juvenile code and the registry requirements, and can lead to registration for juveniles adjudicated of other offenses. Again, the sexting charges, the dissemination of pornographic materials, sexual battery, crime against nature, those are all offenses that I can think of off the top of my head that would potentially require registration for a move to another state, but they are not registrable offenses under 7B 2509. So make sure that you're aware of that. Again, sexting would be either a tier 1 or a tier 2 offense. There's a little disagreement about which one it would actually fall under, but it would at least be an offense that may require registration if the juvenile is adjudicated following the move to another jurisdiction. Just generally advise all of your clients charged with any of the sex offenses listed in 7B 2509, as well as other sex offenses of collateral consequences of adjudication, including registration. Military is an issue for this. Obviously, anytime you have a child who is adjudicated of any offense, if they are thinking of joining the military, there could be issues with it. Some branches of the military with certain sex offenses, this would be an automatic bar, so that might be something that they would have to ask a recruiter, and it would certainly be something that they would be asked to admit to or reveal in the process of trying to join the military. Is there another question, Yolanda?
Yes, it says, is there a time frame where registration in a move to another state is not required?
Not one that I could find. So it looks like it's just if that person was adjudicated, then they would have to register. Again, for North Carolina purposes, once they reach the age of 18, if they were adjudicated as a juvenile, they're not going to have to register. And I can tell you, for people moving into North Carolina, if they have moved here and they're already past 18, they can't go on a juvenile registry, because the way the registry is set up, it is automatic termination at the age of 18. So some of that's going to depend somewhat on the actual state. Again, remember that a move to another state can include out-of-home placements and overnight stays. So I used to tell people, don't let your clients go to group homes in South Carolina, because if they go there, they're going to have to register, because South Carolina used to have very strict registry requirements. South Carolina now has a juvenile defender. Her name is Samantha Luck, and I was able to spend a good little bit of time talking to her about South Carolina's registration offenses. She actually had a case that was appealed, and she was successful in that case, and it led to some changes legislatively for South Carolina registration. And so now I can tell people, if your client is adjudicated of a sex offense and they are not required to register here, then they would not be required to register in South Carolina either. But again, that varies state by state. So just make sure that you are looking at those things, because a lot of times in these sex offense cases, we have the need for a PRTF or a level 3 group home or some other type of specific out-of-home placement. And when those placements are explored, whether or not they have to register is not necessarily completely controlled by whether or not our court ordered it. So look into those things before you allow your client to be placed out of state. Remember, there are immigration consequences. Again, I said we would talk a little bit about collateral consequences, but with the level of these offenses in particular, deportation and inability to file a family-based immigrant petition on behalf of any beneficiary could be an issue. Have those clients consult with an immigration attorney if there's an issue, or you can make that call yourself. Look to our resources, the IDS resources for immigration, and contact an attorney and ask, if my client is adjudicated of this offense, what will happen, and then lay out their situation with their family, who they live with, and what their current circumstances are, so that you can give appropriate advice regarding that. And again, remember, travel issues could exist. So SORNA creates the possibility for federally recognized tribes to register sex offenders who live, work, or attend school on tribal lands, even if the state does not require it. So if they're in a state, North Carolina, South Carolina, any state that does not require registration, the court hasn't ordered it, a tribe could. So tribes have inherent power to exclude outsiders from their territory. Consultation with attorneys familiar with tribal laws might be necessary if this is an issue for your client or your client's family. And again, that's going to bring us up to the resources that were used for this. I wanted to make sure that you had a list of all the statutes that I used in putting this together. Obviously, 7B 2509 is the juvenile registry. 14-208.26 to 208.32 is registration in general, so that would cover your adults as well. You do need to look at 143B for the criminal information network so that you can see how that works for your client's purposes, because again, even if they're terminated off of registration, the criminal information network will retain that information permanently. 7B 3000 and 3001 is juvenile records in general. So if you're asking for the court to seal those confidential records in the file, those are your statutes that you're going to want to look at very closely. 7B 3100 and 3101 are disclosure of juvenile information. And again, that covers Department of Juvenile Justice's directive to notify school if a client has been charged or if a kid has been charged or adjudicated of a felony. And again, now that's going to be the A through E felonies. 7B 3200, I included this one for expunction purposes because sometimes you might have a client who wants to have their juvenile record expunged. Again, the A through E's can't be expunged, but a sexual battery, for example, or a crime against nature could be. So make sure that you're aware of that and that you advise your clients appropriately regarding their ability to have an expunction once they've reached the age of 18 and are no longer on probation. 7B 1501 subsection 7 is the definition of juvenile. Everybody is going to want to go review that with House Bill 834 so that you are familiar with it, because there are now multiple different classifications of what qualifies as a juvenile. Again, your 16 and 17-year-olds charged with A through E felonies for offenses on or after December 1st of this year are going to be charged as adults. But if their date of offense was before that, they're still going to be charged in juvenile court. So that's going to be a little bit tricky to navigate in the coming months. Your federal statutes are here. 42 USC 16901 is the purpose of SORNA, and then 16911 is SORNA itself. So the whole entire statute, it's lengthy. And it references the other statutes that are listed here, 2241, that defines what aggravated assault is. There is another section that is 18 USC 3142, and it creates mandatory bail conditions for transfer cases and 16 and 17-year-old clients. That could be unconstitutional. There was some litigation going on about that, but I'm not sure what the ultimate result of it was. And then there's 18 USC 2250 that makes it a federal offense to fail to register as a sex offender. And that's the one that's important for these clients who are moving from state to state. So the other resources, and these are the websites that I mentioned a little bit ago. So we have the Department of Justice, Office of Justice Programs. Underneath that, the little section C here for the www.smart.gov, that's actually part of the Office of Justice Programs. Both of those websites have the Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking Office. They have a lot of information about the different states and what their specific registry laws are. This is where I found the map that showed which states were SORNA compliant. There's also information on there about which states are partially SORNA compliant and which states have just not adopted it at all. It does have contact information for offices in each state that you could call and ask questions if you needed to. And then the National Conference of State Legislatures just has, in general, laws and information in each state that you could get to pretty quickly and pretty easily. And then I did list this blog post from the School of Government. It is a chart, and this is D, the Criminal Law School of Government SORNA tier chart. It is a chart for all the tiers. And they're very specific in this article that it is open to debate. There's a lot of argument about what qualifies as tier 1, tier 2, tier 3 for North Carolina purposes for adult registry. And they actually say within this body that it's intended only as a guide, but it gives you a lot of good arguments that you can make if you're in court and you have a client who's been transferred up, or you have a 16 or 17-year-old who ultimately gets charged as an adult to begin with. You may want to take a look at this because it does have a lot of good information in it. Then we also have the National Juvenile Justice Network. It gives a list of state-by-state requirements. The one that is listed here actually takes you to a PDF that I'm not 100% sure how up to date it is, but it does give you all of the states and information, so it would at least give you a place to start with where you could get some information for your clients if you needed something in a hurry. I've listed our website, the Juvenile Defenders website, on here as well. For anyone who doesn't know, we were juveniledefender.com. It has been changed to juveniledefender.org, so make sure you change that if you've got it saved as one of your favorites. And then the satellite-based monitoring blog that I referenced a little bit earlier, and I had Yolanda put it in the chat, it's a School of Government blog that lays out all of the revisions to North Carolina laws about satellite-based monitoring. And again, this is going to apply for your clients who are transferred up and are are charged originally in the adult system. But because we do now have this issue with indictments and kids going up or potentially just being 16 and 17 and charged as an adult, you're going to need that information going forward if you don't already know it. So that brings us to the end, and I think we got about 15 minutes left. Are there questions, comments?
Terry, I'm going to put in the chat. Terry mentioned Samantha Luck, who is the South Carolina juvenile defender. She is hosting a webinar, I believe it's next Wednesday, August the 14th, that's going to talk all about the case that Terry mentioned, and then South Carolina's updated registry laws that were really based off the case that she had. So we will send the announcement also in a follow-up email, but this link will take you to the site where you register for it if you're interested. She said it's open to all defenders that are interested in learning more.
And to that point, I can say at least for a lot of the western counties that are close to South Carolina, there is a group home in South Carolina that does sex offender specific treatment for youths, and it's frequently used by counties that are along the border to send clients from here to there because they can't find a placement for a kid in North Carolina, so we're going to send them to South Carolina. So you may want to attend that just so you can get that information, especially if you're in Mecklenburg, Iredell, some of the other counties that are close on the border.
I don't see any more, at least current questions in the chat. I think one thing that could be helpful for folks is when you have a client, for example, that may have parents that reside in different states, say parent resides in North Carolina, another parent resides in Tennessee, what's just some practical things you can do to kind of put that client in the best situation possible?
So for those situations, again, I try to make sure that my clients are, number one, not being ordered to register to begin with, because what I have been told fairly frequently by a lot of states whenever I've had this issue pop up is they will follow whatever is in the order. So once interstate compact, because these are felony charges, because North Carolina only forces registration for the felonies, that triggers ICJ whenever they're going out of state, even though there's a custody order in place if you've got a client who's traveling. So all of that information is going to be forwarded, which means if your client's been ordered to register, they're going to have to register in that other state too. So I try to tell my clients to be very careful of that. If I know that there is an issue where one parent lives in a state that is SORNA compliant and the other one lives here, then I ask them to, at least during the period of the time that this child is on probation, to come visit here so that I can minimize damage as much as possible. You can't necessarily fix it completely if they end up moving whenever they're 18, they're off of probation and they move to that state that's SORNA compliant. So it's a little difficult to, again, fix that completely, but you can at least give them the information so that they're aware. And if they do find themselves in a situation where they ultimately end up being charged, you've given them the information so they know that they shouldn't be staying in that state, because we can't change that particular law, unfortunately, as much as I would like to. So the biggest thing is just making sure that they have all of the information that is absolutely 100% necessary to make the best decisions. I've had clients call me back for the lower not lower felonies, but the lower level sex offenses like sexual battery, and ask to follow up on expungement. So to the extent that you can do that, yes, absolutely, 100%, because again, remembering that those offenses might still trigger registration in another state, if you can expunge it, do it. That way you can at least eliminate that issue for your client as much as possible. The A through E's are going to be harder, and nothing we can do about that, but utilize the things that you can. Again, seal records. I've had a case recently that I asked the judge to seal the entire file, not just the cash evaluation, but literally the entire file, and they granted it. So I'm making it as hard as possible for people to get their hands on that information if I can't erase it completely.
Just making sure I'm not missing anything in the chat, but I think that that's it. Well, I really appreciate everybody for attending today. We will pop our evaluation link into the chat. Nani will send a follow-up email in a little bit after the training that will include the evaluation link. We also a form if you do think you may want CLE credit, and then again, the PowerPoint and materials that we talked about during the training. So we really appreciate you coming. Please reach out to us with any questions. We know that this is an issue that folks experience all throughout the state, and so we wanted to take the time to really dive into this issue. So please, again, help me in thanking Terry for speaking with us today, and we hope you have a great Friday. Thank you, Terry.